U.S. immigration history and policy. As I was working on the slides for this, I was at times overwhelmed by this feeling of nostalgia because it was talking about our government doing normal government things, passing laws and sending them to the president, even though in one case the law just made me want to grit my teeth and go grr. But how long it's been since we've had that kind of just normal political controversy. I hope we can get back to it again. Anyway, this is a U.S. checkered history on living in the rest of the world, and Don has some interesting insights. So go ahead with it.
Well, I'm going to start by going off script to begin with.
Yes.
King Henry VI, Part 2. Jack Cade. Be brave then, for your captain is brave, and vows reformation. When I am king, as king I will be. Everybody, God save your majesty. The butcher. The first thing we do, let's kill all the lawyers. Cade. Nay, that I mean to do. The lawyers follow precedent. Last week I set a precedent, so there will be another reveal. And I brought my copy of the Constitution if anybody wants it. I am dedicating this talk today to the 504 law firms that have just signed a friend of the court brief supporting Perkins Coie, challenging that unfair and I think unconstitutional executive order trying to put them out of business. For those of you that don't know, it's a law firm that's been around since I think 1912. They have been representing a small airplane company for at least many generations. And I just can't say enough about how important it is to convince people that the law is there and we damn well better start following it. Part one of our discussion of the history of immigration and immigration law took us up to 1965, when the United States made its first significant retreat from laws and practices that were and were perceived both domestically and internationally as racist. From a whites-only start, we gradually ended outright bans on immigration from many Asian countries after World War II, but still had a system skewed so that over 94% of allowed immigration from the Eastern Hemisphere was allotted to Europeans, with over 2/3 available for just 3 countries, Great Britain, Germany, and Ireland. It is no surprise that the future Chancellor of the Third Reich wrote approvingly of American racial policy in his book I won't mention by name. As noted in Part 1, Congress passed the 1952 Immigration and Nationality Act over President Truman's veto. That same year, he directed a commission on immigration and naturalization to conduct an investigation and produce a report on current immigration regulations. That report became the blueprint for the 1965 Immigration and Nationality Act. Early proponents for reform included Senator Kennedy, who made immigration reform a major plank in his presidential campaign. The bill had a difficult path into law, primarily because of the opposition of the chairs of the immigration committees in their respective houses of Congress. It finally passed into law in 1965 with the strong support of President Lyndon Johnson, a convert to the cause. A Gallup poll at the time showed that only 51% of the population supported the change. Much of the opposition sounded like a preview of the same arguments prevalent today. The 1965 Act set up a quota limitation on Western Hemisphere immigration for the first time at 120,000 people per year, without any country distinctions. It also set up a 3-year transition for Eastern Hemisphere immigration from the national origins quota system to a total of 170,000 for the entire hemisphere, with a limitation of no more than 20,000 from any one country. Thus, the Indian quota went from 100 to 20,000. The same was true for Nauru, population 12,000. The Act also abandoned its adherence to the post-World War I national boundaries and based country limits on updated boundaries recognized by the State Department as they change from time to time. Thus, people born in Crimea would be considered to be Ukrainians so long as we continue not to recognize Russia's takeover of that peninsula. Some categories of immigrants fell outside the quota system, primarily the spouse or minor children of a U.S. citizen. The 1965 Act also changed the preference categories within the new quotas. It moved to a system favoring family immigration, allocating 74% of visas to family immigration and only 20% to employment-based immigration, with 6% available for a new category called conditional entrants who had fled communist countries or certain Middle East countries. This was the first time our immigration laws included any kind of provision for refugees. Any remaining visas would be available to other qualified immigrants in strict chronological order, irrespective of nationality. The employment-based immigration was divided into 2 categories. The first for members of the professions or with exceptional abilities in the sciences or the arts. The other one for persons working in fields where there was a labor shortage. It set up a system for certification by the Department of Labor that a qualified U.S. worker was not available for the position. I won't discuss the complications of that system. The changes had a dramatic impact on immigration from the Eastern Hemisphere. A statistical chart I found in Wikipedia shows the changed mix of immigration between 1965 under the old system and 1968 under the new one. For instance, Chinese immigrants went from 134 people to over 11,600. From India, it went from 99 people to over 9,700. For Italy, it went from over 5,300 to nearly 20,000. For Korea, from 111 to over 5,000. For Greeks, from 233 to over 14,300. And the Philippines, from 95 to over 20,000. And Portugal, from 428 to over 12,600. In contrast, immigration from the United Kingdom, Germany, and Iceland dropped from a combined total of 56,800 to just over 20,500. In last week's talk, I mentioned the young Italians who moved to Venezuela after World War II and had been waiting ever since to join relatives in the United States. I am sure many of them were among the nearly 20,000 Italian-born persons immigrating to the United States in 1968. This leads me to a digression. The State Department frequently received letters from members of Congress asking why a relative of a constituent had not been issued a visa. Many of these came from New Jersey congressmen with Italian names, with inquiries from their Italian constituents asking about a brother waiting for years for a visa. Diplomatic Post had a procedure for handling these. After a careful review of the file and noting congressional interest on it, the embassy would reply to the congressman very politely, stating that the entire quota for visas for Italians was used up by the 3 preference categories. Therefore, there were no visas available for the Italian-born persons in more preference categories. It then assured the congressman that it would carefully monitor the case and issue a visa if and when the constituent's term came up. There was a real temptation to add a sentence saying to the congressman that he damn well knew no visa could be issued, so fix the problem. I later realized that these congressmen were among those seeking to change the law, and these letters and responses were part of their ammunition to convince other members of Congress to support the proposed 1965 Act. The rules in 1965 were further modified in 1976 and 1978, first placing a 20,000 person quota limit on each Western Hemisphere country, and then merging both the Eastern and Western Hemisphere systems into a single system with a worldwide quota of 290,000 persons, excluding certain immediate relatives. The changes wrought by the 1965 Act and further changes in 1976 and 1978 permanently skewed future immigration, often in ways that could not be foreseen. Eventually, Congress passed the Immigration Act of 1990, substantially modifying the system. I will discuss one of these changes in a later section on the temporary protected status. Some of the major changes of the 1990 Act include the following. It expanded the worldwide quota for immigration to 480,000 per year, while narrowing the definition of family. It divided employment-based immigration into 5 occupational categories from the 2 categories of the 1965 Act, and made other modifications in the system. It set up a new diversity immigrant visa category. Due to changes in immigration patterns in the over 20 years of operating under the new system, it became increasingly difficult for persons from some countries to obtain visas. Starting in 1991, every year the government divides the regions and countries of the world into 2 classifications: high or low admission based on immigration patterns of the previous 5 years. Each year, up to 50,000 qualified persons from low admission countries can obtain permanent resident status under this program. The initial group of 31 countries included mostly European countries as well as Argentina and Japan. Qualified persons from designated countries had to have a high school education or 2 years work experience plus 2 years of job training. Spouses and children of the qualified persons also could immigrate with them. Selection of persons for this program is done by lottery for those who apply. This has been called the lottery program. Our current president in his previous term disparaged this program without any understanding of it. I know 2 families who entered the United States under this program. The first from Lithuania are a husband and wife who have DMA degrees in music. One heads the keyboard music program at Seattle Pacific University, and the other teaches at a community college. The other family is from Ethiopia. The husband has a trucking business in Seattle, and the wife owns and operates the adult family home in Mill Creek that took excellent care of my wife for the last several years of her life. They own the house next door, and their kids are thriving in honor programs at the high school. Congress has not made any significant changes in this part of our immigration law since 1990, and some clearly are needed. For instance, no one anticipated in 1965 that India would become a major source for leaders in the technology sector. Over the years, thousands of talented Indians have come here, usually on temporary worker visas, and many qualified and became permanent residents. Unfortunately, the immigration law still sets the same limit on immigration from a single country, irrespective of its population or pressure for immigration from it. The employment-based portion of that quota is still only a small portion of that total. 2 law school professors looking at the backlog for these slots recently with respect to people from India, estimated it would take over 100 years to clear it out. In the meantime, Canada has become a beneficiary as Microsoft and others have set up alternate operations in Vancouver. More recently, companies have begun to outsource some of their highly technical jobs to subsidiaries in India. Unlike manufacturing, this outsourcing is immune from any punitive tariffs. Congress passed the Immigration and Reform Act of 1986 during the Reagan administration. Among other matters, it provided a path to lawful permanent residence for otherwise qualified aliens who had been continuously in the United States in unlawful status since January 1st, 1982, irrespective of whether they had overstayed their permitted stay after entering illegally as a non-immigrant or had entered the United States illegally. They had to meet almost all other requirements for permanent residence with one important exception. They would successfully bypass the country quota system. This act also created the sanction program applicable to employers who knowingly hired non-citizens without work authorization. It was thought the creation of the employer sanction program would discourage employment-based illegal immigration. Recognizing that the agricultural industry was the major employer of unauthorized aliens, it also created a new temporary worker program for agricultural workers. If this law was designed to reduce unauthorized immigration, it was a failure. 3 million persons applied for adjustment of status out of the estimated 5.5 million unauthorized aliens in the United States at that time, and about 2.7 million were awarded permanent residency. Wikipedia estimates that by 2013, the population of unauthorized aliens had risen to over 11 million. Now, starting about 2007, there were several failed attempts in Congress to provide a new path to permanent residency for certain undocumented immigrants. One of these was named the DREAM Act, or DACA. One of its principal provisions would benefit young persons brought here unlawfully by their parents at an early age. When it failed, President Obama set up a policy to allow dreamers to escape deportation and obtain work permits for 2 years, renewable upon good behavior. Eligible applicants were persons younger than 31 on June 15, 2012, who came to the United States before the age of 16 and lived here since 2007. There were several other requirements I will omit. Persons from Mexico, El Salvador, and Guatemala dominated, and the largest number lived in California and Texas. Number 45 failed in his efforts to kill this program after considerable litigation up to the Supreme Court, but only based on procedural issues without reaching the merits of the case. President Biden reinstated the program by executive order. Things got murkier after that. Stay tuned. Let's go back now to the other major change after 1965, starting with passage of the Refugee Act of 1980, enacted in the last year of the Carter administration. Section 101 of the Act stated clearly that its objective was to provide a permanent and systematic procedure for the admission to this country of refugees of special humanitarian concern to the United States, and to provide comprehensive and uniform procedures for the effective resettlement and absorption of those refugees who are admitted. It further stated that it is the policy of the United States to encourage all nations to provide assistance and resettlement opportunities to refugees to the fullest extent possible. Refugees were generally defined as persons outside of the country where they last resided, unable or unwilling to obtain the protection of the country to which they had moved, and unable or unwilling to return to their country of origin because of persecution or well-founded fear of persecution on account of race, religion, nationality, membership in a particular social group, or political opinion. The spouse and children of a qualified refugee were also included in the term refugee. This definition of refugee did not include so-called economic refugees. The Act set the quota limit of 50,000 persons each year from 1980 to 1982, but it left it to the determination of the President to set the limit in subsequent years. Only one president has lowered the limit through the end of 2024, number 45. The Act also set up a second category of refugee when the President has determined that an unforeseen emergency situation exists or where it is clearly in the national interest and the refugee does not meet the requirements for falling into the first category, usually because they were still in their home country. The President determines the number of persons to be admitted in this category each year, and the designation was only effective for 12 months but could be extended on an annual basis. Persons coming into the United States under this program had the same status as other refugees admitted under the first category. They included, among others, people from Afghanistan whose lives were in jeopardy if they remained in Afghanistan after the Taliban regained control. Our church sponsored an Afghan family that entered the United States in November 2019 under this system. The husband had been a driver for the U.S. military in Kabul. They live in Linwood and are thriving in their new home. Persons entering the United States under these programs became lawful permanent residents of the United States upon entry with a normal path for citizenship. One of these who completed this journey is my barber in Wedgwood neighborhood. He is a Shiite Muslim originally from southern Iraq and ended up in Saudi Arabia after the first Iraq War. He became a citizen about 25 years ago. Yes, I do go to a barber. Easy money for him. The Act waived some of the ordinary grounds for inadmissibility to the United States for persons entering under the refugee program. These included the requirement for Department of Labor certification mentioned earlier and proof that the alien would not become a public charge. Consequently, the Act created an Office of Refugee Resettlement to coordinate and administer programs for domestic resettlement and assistance to refugees. The goals of this program were to make available sufficient resources for employment, training, and placement in order to achieve economic self-sufficiency as quickly as possible, to provide refugees with the opportunity to acquire sufficient English language training to enable them to become effectively resettled as quickly as possible, to ensure that cash assistance is made available to refugees in such manner as not to discourage their economic self-sufficiency, and to ensure that women have the same opportunities as men to participate in training and instruction. The resettlement program was set up to work with the states and nonprofits to achieve its purposes. This system included grants to state and local governments. Of the 50 states, only Wyoming failed to participate. Persons qualifying to enter the United States under the refugee programs underwent a rigorous vetting by the State Department and the relevant government agencies before being accepted to qualify as a refugee and enter the United States. As of January 2025, approximately 20,000 refugees had been fully vetted and were awaiting transit to the United States from countries such as Afghanistan, Syria, and the Congo. The new administration issued an executive order shutting down this program on its first day in office. Apparently, however, the extension cord to the chainsaw has not reached Cape Town, as the new administration is now setting up a refugee resettlement office there for Afrikaners. The Act also created a system allowing aliens already physically present in the United States or at a land border or port of entry to apply for asylum. The criteria for this status were identical to the refugee criteria, except for location of the applicant. Again, it did not apply to economic refugees. Up to 5,000 persons granted asylum under this program could apply for adjustment of status to a permanent resident each year. To do so, they must have been present in the United States for at least a year after obtaining the asylum status and continue to meet the other criteria for refugee status. Persons in asylum status have a tenuous right to remain in the country before they adjust. There are procedures by which the government can determine that the asylee is no longer eligible for that status because of circumstances in the asylee's home country have changed. I did not research the legislative history of the 1980 Act, but judging by its structure, it appears that these asylum provisions were an add-on to the original bill. In contrast to the refugee program, persons claiming asylum often had no prior contract with U.S. authorities until they showed up at the border or port of entry. Thus, they had not gone through the rigorous vetting process of the refugee program before arrival. Unlike the refugee program, the asylum system has been one of the programs most subject to abuse over the ensuing years. In my opinion, the source of this problem lies with the government itself. The agency responsible for its implementation, the Immigration and Naturalization Service within the Attorney General's office originally, and now ICE under the Department of Homeland Security, has never had the resources or the competence to run the program successfully. Theoretically, a person claiming asylum should have his or her claim adjudicated on a timely basis soon after application. Instead, applicants with at least a plausible claim have been admitted conditionally pending a hearing on their application. The time gap before adjudication of these claims has grown exponentially over the years. This phenomenon is not new. I have a story from 30 years ago. A prominent family had an older member who needed assisted living and had a full-time caregiver here from an unnamed foreign country. They knew the caregiver had authorization to work, but was not a lawful permanent resident. They asked me to assess the problem. I learned that the caregiver had entered the country illegally and later applied for asylum status several years prior to her employment. After talking to the woman, I told the family that in my judgment her claim had no merit and that the woman knew it. I also knew that her case would not be adjudicated for several more years. I have no idea of the outcome, as the caregiver's employer died well before any hearing for the asylum claim was scheduled. The international grapevine works at least as well as the one here at University House. And the word was out long ago that anyone reaching the border with at least a semi-plausible claim could take advantage of the weaknesses of the asylum system. Much of the so-called immigration crisis upsetting many Americans and fanned by the Trump mob can be traced to this failure. I previously mentioned that the 1990 Immigration Act set up a system of what is called temporary protected status, or TPS. This status is available to people from designated countries already in the United States when there is an ongoing armed conflict, an environmental disaster, or other extraordinary and temporary condition in the home country. Such people can get work permits and are protected from deportation. The Secretary of Homeland Security designates when a country merits TPS designation. The designation can be set for 6, 12, or 18 months and may be extended or terminated upon publishing a notice at least 60 days in advance of the expiration date. If no notice is filed, the designation automatically will be extended for 6 months. There is no statutory limitation on how long the designation for a specific country can remain in place. As of the beginning of this year, 17 countries had been designated under this program. A total of 12 countries have been designated in the past and later had that designated nation terminate. Spoiler alert, the new administration terminated the TPS designation for Venezuela, and it will officially end on April 7th. It also reduced the TPS status deadline for Haiti to end on August 3. The TPS program suffers from some of the same ills as the asylum program, as it encourages people from countries subject to TPS status to enter the United States any way they can in order to apply for status once they are here. There have been several other tweaks to the immigration system since 1980. I will discuss some that are relevant to the present summary. Legislation in 1996 and 2002 mostly related to border security, but made a few other changes that merit discussion. The Illegal Immigration Reform and Immigrant Responsibility Act of 1996 substantially modified the deportation process to expedite the procedure and limit a number of avenues for relief. The process takes place within the Department of Homeland Security structure with administrative law judges, but people are entitled to an attorney at their own expense. The new rules apply to both non-immigrants and immigrants. I do not intend to get bogged down in the minutiae of these changes, especially since it is an area about which I have limited knowledge. However, the changes are relevant to recent developments we have been reading about every day. The Enhanced Border Security and Visa Entry Reform Act of 2002 was a response to the 9/11 attacks, mostly done by perpetrators who were here with student visas. It was designed to strengthen protection against further acts of terrorism. It set up an electronic monitoring system for student and exchange visitors. The present administration has availed itself of this system to track the activities of some of the non-citizen activists being deported at the present time. One section prohibits the admission of persons from, quote, a country designated to be a state sponsor of international terrorism, unquote, unless the Secretary of State determines that such individual does not pose a risk or security threat to the United States. I believe the new administration has come out with a list of countries on a new blacklist. The last topic today is deportation law as viewed by the present administration. I admit relative ignorance in this area. The basic rule relevant to today's discussion can be found in 8 U.S.C. section 1227 and a bunch of other numbers after that, which states, quote, an alien whose presence or activities in the United States the Secretary of State has reasonable ground to believe would have potentially serious adverse foreign policy consequences for the United States is deportable. The present administration used this provision to deport Mohammed Khalil, the Columbia student, and continues to invoke it in other recent cases. The administration has clearly stated it will use it proactively in the future. My limited research indicates that the present language is a revision of the original provision in the 1952 Act and was inserted in the 1990 statute discussed earlier. Commentators state it was intended to be used sparingly. Trump's deceased sister, a federal district court judge at the time, ruled in a 1996 case that the provision was unconstitutional for vagueness and also because it was an improper delegation of legislative power to the Secretary of State. Unfortunately, the case was reversed by the appellate court on grounds that the case was brought in the wrong forum. The appellate court opinion was written by Judge Samuel A. Alito, Jr. I have come to the end of this wild ride through the morass of immigration and immigration law. It is time for a few observations for what they are worth. 1, no modern country can permit unlimited immigration, so some restrictions are and will be necessary. 2, our present system, with all its flaws, is still an improvement over some of our past history. 3, we lack a consensus and a common will to come together to correct obvious abuses of the system without backsliding from many of the positive changes in our policies since 1965. 4, the United States is one of several countries facing a contracting base of permanent residents and citizens moving into the working years and with an aging population. This situation is more serious in some other countries, particularly Japan, Korea, much of Europe, and even China and Russia. 5, we in our generation fully realize how much our country is dependent on new arrivals able and willing to provide needed support for our economy. 6, we and many other countries need a certain level of immigration to maintain our economies and our social framework. 7, it is in the national interest to have rational immigration policies that encourage an appropriate level of immigration and integration into our society. 8, I haven't the foggiest idea how to get from here to a better place. 9, hang on, it's going to be a rough ride.
Thank you.
Do you know, well, I wonder if anybody else knows, does immigration depress wages?
That's not something I really know. I know that's always the claim, but I'm not. The people coming in high tech certainly aren't depressing wages.
Don, do you have any detailed feeling as to the extent to which Emperor Trump is abusing the existing immigration laws?
Every step he can.
Pardon?
Every step he can.
Yeah.
Don, remind me, please, why is immigration important?
Because we are, if you take away the immigration, we are a declining population in the workforce. And besides, it doesn't do any harm to find out that people have good ideas that weren't born in Seattle or anywhere else.
Thank you, Don, for the clarity and scope of what you've offered to us. Would you agree that the system as we have is not only abused, but in fact it's totally broken because those who have been given paroles after detention and allowed to make an application for asylum, there are millions of those. They have cases pending. They have been in the country anywhere from up to the one case I know absolutely about is 13 years. So would you comment on the plight that we put these people in who under U.S. law and international law have the right to be here and apply for asylum?
I would say, first of all, among the people that are waiting for asylum or to have their cases adjudicated are many who are not entitled. But the problem lies because we have never put the resources into the job of getting these people's cases adjudicated quickly. So so that those who are eligible are immediately allowed to get off this column. And those that are not would then be taken care of under other rules. I know of many cases where one member of the family gets here, and they can't even bring their spouses until they get a hearing. That's tragic.
Two comments. The Northwest Immigrants' Rights Project, which is one of the leading agencies that's working in immigration right now, their funding for unaccompanied minors was withdrawn, so they no longer have funds, even though they're required by law to have representation for unaccompanied minors. They don't have money to provide that, which is what they were doing. And secondly, I've been doing translation interpretation for them. And my experience, contrary to Trump's claim that most of the people coming here are all drug lords and drug sellers and all, most of the people that I've worked with are actually fleeing the drug lords and drug trafficking persons in their home countries.
That appears to be the case of the El Salvador guy from El Salvador who was deported for administrative error.
And they can't bring him back.
There are a lot of very meritorious cases, and that is not the only organization that's been defunded. Most of the church groups that have been sponsoring these people have also had their money cut off. I found out one Sunday morning that I worked for a criminal enterprise that launders money. I thought it was just a church.
Oh, those Lutherans. Vida?
I can't do much now, I don't think anymore, but I still handwrite checks. So for those of you that have agencies that you believe are underfunded, let the rest of us know where that money would go for a very good cause. I need help in that determination.
Thought it might be interesting when my husband from a German Jewish family needed to escape Germany in the 1930s. There was no way that he would get a visa for this country. In 1957, we were made welcome. Come on in, come on in. He had turned himself into a nuclear physicist. And this was the year of Sputnik. And yay, we need you people. Listen, people. It's idiotic.
Our role in dealing with the refugees from the World War II is atrocious.
Our role
Well, at that time, we had our country designation, so that, for instance, the quota for people coming from Romania was a few hundred per year. The number of Jewish people trying to get out of Romania was several thousand. And I've been told by some people that some of our consulates were not issuing visas, they had visas available. But we did not do anything to change our restrictive laws to help these people.
There's a very excellent PBS series on that very subject. As Jewish people tried to get to the U.S., in fact, their boat was turned around with State Department encouragement and help. And for some reason, President Roosevelt, the great liberal, didn't step in and take any interest in it.
That's why so many of them ended up in Venezuela and places like that.
Yeah.
Yes, I just want to reiterate what Rita just said. I've been trying for weeks to get the names of where I could send some money. No one can tell me anything except the ACLU, which I belong to. But Alan Paulson gave me that good quotation that they use, that you have time, you have treasure, or you have talent. If you don't have the time, you might have the treasure. If you don't have the talent,
you might have the treasurer. So if anybody knows anywhere besides the ACLU that I could legitimately, I get like 20 different requests from different places every day, but I don't want to send my money unless someone here, if Patty has the name of a particular place, that's cool.
So I know a few of these organizations, besides Newark, and I'll be willing to put together a list. Other people in the room know other organizations. So if you just want to send me the names of local organizations that are working on immigrants' rights issues, I'll compile a list and see that it gets distributed somehow.
Epic,
Alan Walson.
Epic Shelf up on the first floor.
What? Oh,
For
have people just write it down?
Yeah, for distributing stuff.
Oh, yeah, okay, sure.
Did you hear what Rita said? Our shelf, our kiosk?
How about something broader than that?
Yeah. Email.
Franklin Roosevelt turned away a boat that was docked on our shore of 1,000 refugees, sent them back to Europe, and they were all murdered.
Right.
That's our liberal President Roosevelt.
Yeah.
We had one who survived, named Henry Brescher, who ended up in the Quaker boarding school that I went to, who died recently and left all of his estate to the school, which was a place that literally was his salvation. And his story is incredible.
Well, it's an interesting how this shows the best and the worst.
Anyone else? I'm just curious, how many of you people in here have either parents, grandparents, or great-grandparents who immigrated to this country? Just raise your hand.
Almost everybody.
Yes.
Mine came from Norway, and that was the nice country.
So I'll have the opposite of that. How many in this room have migrated to another country?
From where?
Say it again.
How many people in this room have migrated to another country?
Oh,
As in, was a legal migrant to another country. I migrated to Australia. And I wondered if there was anybody else that had migrated from this country somewhere else.
Might be going to Canada pretty soon.
Victoria could be nice.
I don't know how interesting that is, but my grandchildren, some of my grandchildren, and I know other families in similar situations, are asking about my family background because they're thinking seriously of going back to Europe. They just have had the US too.
Yeah, I've had that too.
Yeah, I have a niece who's working on French citizenship now. Thank you. Thank you, Dawn.